The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near and they will be heard. God save the United States and this honorable court.
Good morning, everyone. We have 5 cases that we're going to hear today, and we may or may not take a break between now and then. The first case we'll have is U.S. versus Eckstein, and it's 24-31-38, and we'll hear from the appellant.
Good morning, Your Honors. May it please the court. Justin Lallman for the appellant, Michael Eckstein. I'm going to aim to reserve 2 minutes of my time for rebuttal. Rule 11 draws a bright line rule absolutely prohibiting all forms of judicial participation in the plea negotiation process. It doesn't matter whether the participation was minor, unintentional, or even well-intentioned. The rule admits of no exceptions, and the rule was violated in this case. Now, the government and defense don't agree on a whole lot, but one thing we do agree on is that the court needs to review this in the context of the entire record. The record in this case shows that Mr. Eckstein's retained counsel, Carl Cornwall, called to advise the court that his client wished to enter a change of plea. The record reflects that 2 days after placing that call to the court, counsel called his client to explain to him the deal that he had already committed the court that he wished to accept. Mr. Eckstein didn't have a copy of the plea agreement. He didn't understand it. The connection on the call was not good, and Mr. Eckstein told his attorney that he did not want to proceed with the plea, that he wanted more time. At that point, Mr. Cornwall became angry, and that anger billowed over to the change of plea hearing.
Counsel, can I interject for a minute? I have a lingering question that I hope you could address concerning Mr. Cornwall's request to withdraw. And it seems that right at the top of the change of plea, he indicated that he wanted the court to entertain his motion to withdraw. Doesn't seem that the court ever resolved that. The change of plea hearing proceeded. And I wanted to ask you how we should be thinking about the fact that counsel sought to withdraw, that was before the court, but never, as far as I can tell, meaningfully resolved.
Sure, Your Honor. I think the issue in this case is the plea agreement and the decision about whether, the decision whether to go forward with the change of plea and the decision whether to have a substitution of counsel were really intertwined on this record. Mr. Cornwall starts out by making clear that he doesn't have any interest in representing Mr. Eckstein unless Mr. Eckstein is going to plead guilty. And so his representation is contingent on that. The court goes through this discussion nominally about whether or not whether Mr. Eckstein wants to replace counsel. But intertwined with all of that is the condition that Mr. Cornwall put on his representation, whether Mr. Eckstein wished to accept this plea. And so once the court makes these comments that advises Mr. Eckstein that it has a personal concern that if he does not go forward with Mr. Cornwall as his counsel, that the government may withdraw this plea offer, it's at that point that Mr. Eckstein says, I want to go forward with this plea. You're right, Judge. I don't want to lose this plea. And it's at that point that Mr. Cornwall says, I'm ready to go, Judge. And so I think at that point the issue is in many ways mooted or withdrawn based on Mr. Cornwall's statement that I'm ready to go, Judge.
Does it have any effect on how we should be thinking about coercion?
I certainly think so, Your Honor, because in this case, the attorney throughout this proceeding is threatening his client openly, saying, I don't want to represent this man unless he's willing to accept this plea deal that I've negotiated for him. And there's nothing in the record where the judge, tells defense counsel that's your client's decision. That's a decision for him to make. And instead, the court's making comments to the defendant, telling him this attorney is very experienced, very skilled. In my experience, he cares very deeply about his clients. The court tells the defendant that if he does not go forward with Mr. Cornwall as his counsel, that Mr. Eckstein may not qualify for appointed counsel and so may have to represent himself or go hire another attorney. And so it's Mr. Cornwall's threat is hovering over all of this proceeding. The conditional representation that he's only willing to provide if Mr. Eckstein will plead guilty is embedded in the background of this entire case.
Well, Mr. Lowman, given the emphasis you put on maybe suggestive coercion from the lawyer rather than the court, let me give you a perspective that is at least arguable and tell me why it's wrong. And as you begin with Rule 11, and it says the court must not participate in these discussions, meaning discussions to reach a plea agreement. All right. And then as we get into the hearing, the court sees that she has to address this representation issue because this guy is saying, I want to withdraw. And so they close the courtroom and they have this proceeding to protect privileged communications, or just to protect the defendant. And a perspective is the thrust of this whole thing was the court quite appropriately addressing the representation issue. And she did so throughout. There's just a couple of lines in the transcript that she says, in connection with the representation issue, that this government doesn't have to stick with this plea if it's delayed. And she says that twice, but the overwhelming thrust of the transcript indicates this is an issue about representation, not the court interfering in the plea discussions. Why is that a wrong perspective?
Sure, Your Honor. So 2 points on that. I think principally where the judge really crosses the line here is when the judge says, I'm at a loss for what to do here. My concern, expressing it as a personal concern of the court, is that if you go forward with seeking substitute counsel, the government may withdraw this plea and not re-extend it to you. So how do you want to proceed right now? And so the judge is actively linking this decision about what do you want to do with your counsel to the ongoing plea negotiations. There's no record in this case that the government had ever communicated any sort of timeline or deadline on its plea offer. The government, or the court, though, expressed it as a personal concern. The other thing I would note is going back to Cano Varela, this court's main case, the kind of factual circumstances there were the same as far as what was leading up to the hearing. In that case, the defendant had communicated that he wanted to accept a plea agreement. Right before that, he changed his mind and said, you know what, I want a new attorney. I don't trust this attorney. I want somebody new. And so the court held a status conference. And the status conference was mainly focused on whether or not they were going to replace counsel. And during the course of that, the parties got into plea negotiations. The comments in that case, I acknowledge, are different than what we're dealing with here. But these issues were intertwined there just as they are here. And in that case, the court recessed the proceeding for a few days after making these comments, allowed the defendant to go and decide whether he wanted to get new counsel or whether he wanted to continue with his counsel and take this plea or go to trial. And eventually the defendant came back and entered a plea, and the court in that case reversed. And so I think just because we're talking about two things here, counsel and the plea, they're very clearly intertwined on this record. And the court's comments, they're not just intertwined by Mr. Cornwall, they're intertwined by the court in this comment as far as tying the decision about counsel to the potential impact of ongoing plea negotiations.
So you're viewing it as a coercion by the court rather than the court participating in the plea negotiations?
Sure. Well, Your Honor, I don't know that the rule is not limited to judicial attempts to outright coerce or threaten a defendant. The rule broadly prohibits any judicial participation in plea negotiations, full stop, whether the judge had only the best interest in mind or whether it was completely inadvertent or unintentional. So And so I'm not saying that the judge had some secret motive to try and coerce the defendant. The rule is not so limited. It just bars participation.
Does your, do the circumstances of counsel's wanting to withdraw affect the B1D issue as well?
I think so, Your Honor. In this case, on that issue, we have agreement that there was error and that it was plain. And so the only issue is whether there's a reasonable probability that Mr. Eckstein would have not accepted this plea had the court advised him that he had a right to appointed counsel if he could not afford counsel. And on this record, it's clear that this relationship is toxic, that they do not get along, that there is not trust. And he is very reticent to accept this plea. And again, at the third plain error prong, our burden is just to show a reasonable probability. It's less than a preponderance. It's just a probability sufficient to undermine.
Well, what are we looking specifically for that without the that had he known he was eligible or could go through the eligibility determination for appointment of counsel, that he would not have taken the plea?
Yes, I think that's the issue. And I think the evidence here for that is just his reluctance throughout the whole first half of this proceeding to go forward with this agreement. And then layered over that, all of the issues with this relationship. It's clear from the record that this was not a good relationship. Defense counsel recognized on the record that the attorney-client relationship had completely broken down.
Well, at one point, your client does say, he says, I mean, it's not even him. I mean, he sort of distances himself or his decision-making from whatever conflict he may have had with his attorney. How should we be thinking about that?
So, Your Honor, I think part of that is that comment comes after the judge has participated in the plea negotiations, after the judge has made these comments. And
so we have to find we have to agree with you on the C1 error then in order for the B1D error to be availing. I didn't think those issues were linked.
Your Honor, I think they are related. I don't know that you have to rely on it. I do think it's a circumstance to consider in this case is these comments, whether they rise to the level of participation in the court's mind or not. It's very clear that the court's comments were a motivating factor that changed this defendant's mind. And this court, other courts have recognized that any participation by the judge in plea negotiations, no matter how minor, exerts pressure. And I think you see it in this transcript from those comments. But even more broadly, just going back, even without those comments, we still have a very clear record of an entirely broken down relationship that is distrustful. Those comments do come later, but I mean, I think those comments also followed after the court expressed doubt about whether this client would qualify for appointed counsel. And
Can
so
I ask Mr. Loman, well, go ahead and finish your answer.
I was just going to say, these comments came after the court expressed some doubt or reservation about whether Mr. Eckstein would qualify for appointed counsel, which I think this court needs to also take into account. Okay.
I just want to go back to the 11C1, and I just really have one question and try to let you have your rebuttal time that you wanted. What if Judge Teeter had said, the government, that offer may not be here, but the government, I have no reason to believe that the government is going to withdraw that offer. I'm just telling you, that is always a possibility. It may be a possibility of 0.1 here. And she did say, I don't know whether this is a good plea deal for you or not, but what if I think Judge Rossman mentioned, or somebody mentioned that she reiterated that twice. What if you mentioned that 4 times? It would if, and I know you argue that it doesn't have to be satisfy plain error, but if we reject that and if we do apply the plain error standard, would it be an obvious error under prong 2 if Judge Teeter had reiterated? I have no idea, they've never said that they're going to withdraw the offer. It may continue to be available 3 months from now. I'm just telling you, I don't know any of these things. Is that an obvious participation in the plea negotiation?
Your Honor, I don't have a case that would say that that would be obvious. I think that the rule itself, though, is very broadly written as far as any participation, and this court can recognize a plain error just based on the text of the rule itself. In that case, the judge is discussing potential threats or potential leverage that the government could exert in plea negotiations, which I do think falls within the rule. This is clear. That would clearly be a lot better thing to have said than what was said on this record, but the court expressed it as a personal concern of the judge.
Okay. Judge Rossman or Judge Murphy, did you, you're out of time, but do you all have any additional questions? Okay. Judge Murphy, you're on mute, by the way, but I think you shook your head no. So we'll hear from Mr. Magg.
Good morning, Your Honors, and may it please the court, Jared Magg on behalf of the United States. Judge Bacharach, I think I'd like to start kind of where you left off because, again, Cano Varela specifically states that Rule 11 doesn't establish a series of traps for imperfectly articulated oral remarks by the court. And, you know, and as Mr. Lallman said, and we agree, you cannot look at those remarks in isolation. You have to look at exactly what Judge Teeter's concerns were here. And as much as the defendant insists that this case is about the plea agreement itself, our position is that it's not. Again, telling the defendant that the government is not under an obligation to continue the plea merely informed him that if he insisted on getting new counsel, that he should be informed that he will not possibly be placed back in the exact same position that he is today. And the government's position is that kind of statement ensures the defendant is making his decision about counsel with eyes wide open. So you have to look at exactly what the statement was designed to do.
Is it the government's view? Is it the government's view that Judge Teeter ruled on the motion to withdraw, or that it became moot, or what is the government's position on Mr. Cornwall's motion to withdraw?
Thank you, Judge Rossman. Our position is consistent with Mr. Lallman's position on that once the decision was made that Mr. Eckstein was willing to move forward with the plea, Mr. Cornwell's representation sort of followed right along with that, and that it was exhausted based upon that decision alone. There certainly isn't anything in the record to suggest that Judge Teeter ruled definitively on his motion to withdraw. We're not standing here saying that she did, but we do agree with Mr. Lallman that it was sort of hand in glove when Mr. Eckstein decided to enter his guilty plea.
So maybe you could help me with something I'm struggling with on the B1D issue. I mean, the government agrees that there was a plain error there because of the failure to explain the entitlement to appointment. But on the third prong, it seems to me that we have circumstances where it's not just that Mr. Eckstein got this information early on at the arraignment, which our cases say is probably enough, but that there was misinformation at this particular ex parte hearing, because the court says you don't deal with this and move forward, we're going to have to send this back to the magistrate judge. And that sort of presentation, at least on my read, might suggest that that's some misinformation. It's not just the absence of information that he may have received and is cured by what was said at the arraignment or earlier on in the proceedings, but this sort of connects those dots in a way that concerns me on the third prong. So I wanted to know what the government's position would be on how I should be thinking about that, whether it was a misinformation, a misstatement, rather than the absence of information alone.
No, I don't believe it was a misstatement on the court's part, because she certainly had an obligation to tell him, given the fact that obviously he had been in custody for some time. He had hired Mr. Cornwell to begin with, but there had to be a determination in the event that a decision on new counsel was in his favor, that he would actually qualify either for appointment or he would again have to retain counsel based upon his financial circumstances. That decision would have to be made And I think she was just simply informing him of that fact, which it's not a misstatement. They would.
Well, I think what's troubling is that you're right. It is based on his financial circumstances. But what the court's presentation suggests is it wasn't linked, eligibility wasn't going to be based on that. It was really going to be based on whether he wanted to take this deal or not. And that seems different than the sorts of cases where the court is just passing on eligibility very generally. Maybe it's not a full statement, but the defendant got the correct information earlier on. This is sort of linking the eligibility to whether you're going to take the deal. And that's the problem I'm having with is perhaps favoring the appellant's position on the third prong.
Well, I guess I would counter with this, Judge, and I can appreciate that understanding of the record, but in looking at what Mr. Eckstein said, it seemed that his sort of concerns revolved around his ability to read the plea agreement itself, and that was part of the reason that he was struggling with whether or not to move forward, was he wanted to get a better understanding. And I think it should not be lost on the court that Judge Teeter gave him the opportunity to extend the hearing out through Thursday so he could sit down and read the plea agreement. So it wasn't as if she was forcing him into a decision that day. She gave him the option to take the time that he needed. She was not insisting that he move to a plea that afternoon. And so in the circumstances of what Judge Teeter was doing here, we believe she was taking every step to ensure that the defendant's rights were protected and not trying to coerce him into doing anything that he didn't otherwise want to do. His decision obviously was, and again, from a cold record, it's sort of hard to understand maybe what the tenor of his responses were at the time, and sort of the tone of Mr. Cornwell's statements and all of that. So we don't want to ascribe something to the record that may not be there. Everything about the record suggests that Judge Teeter was there to protect the defendant's rights. And so we don't see the level of coercion that the defendant sees under the circumstances. But again, let's not forget here what the question presented is. This isn't a case about coercion on the part of Judge Teeter. That is not briefed. That was not presented by the defendant. The government has not had an opportunity to respond to any claim of coercion. This is a case about whether or not the judge ran afoul of Rule 11C. And again, our position is that under the circumstances, when you look at the totality of the record, you'll find that her statements were geared toward Mr. Eckstein's decision to make an informed decision on whether or not he wanted new counsel. And I would echo what Judge Murphy said, that Judge Teeter's saying that the obvious fact, and again, Judge Bacharach, I think, appreciated this as well, the obvious fact that a judge might want to inform the defendant, please understand that if you get new counsel, you should not expect to come back to this court and say, okay, I'm here to plead today, because the state may decide it has changed its mind.
Well, can I push back on that a little bit? Because I may be misremembering the record, but I thought Judge Teeter, when you said that, she was willing to adjourn for the defendant to talk with counsel, to have him go through the plea agreement, and you mentioned about deferring the change of plea until Thursday. I thought that that was the point in which Judge Teeter said, look, we can break, but they may not, when we resume, the government may not be willing to make that same plea deal. So, but whether that's true or not, let me ask you in the form of a hypothetical, because any plea we've all litigated, and whether it's civil or criminal litigation, and part of plea negotiation or civil negotiations, plea negotiations, I would assume involves an ingredient of pressure, showing leverage, that you have more downside to rejecting whatever I'm offering civilly or criminally than to accept. And if Judge Teeter had said, look, I will break for an hour and you can go through this plea, may not be a good plea deal for you, but I'm just telling you, in 1 hour, there is a chance that the government is going to withdraw that plea. So good news and bad news. I'm going to give you time, but that time may be for naught if, hypothetically, Judge Teeter knew that in the history of the District of Kansas, no one in your office had ever done such an amazing thing, which I think is probably true, to revoke a plea offer, because the judge takes a break for 45 minutes or an hour. Would that create an obvious participation, not because of pressure, because you're right, 11C1 is participation, but isn't that participation in the negotiation if I'm going to say, as a judge, you can take a break and you can understand it, but you may have just frittered away your one and only opportunity to get out of this without a trial?
Judge, I think in a vacuum that gets closer to the line. But here, I think what we have to appreciate is what Judge Teeter said repeatedly to Mr. Eckstein. And even after he makes the decision, she reinforces with him, look, I am not telling you, you have to take this plea. She does this on a number of occasions to ensure, I think, herself that she had not crossed the line. And she wanted to ensure herself that she herself had not coerced him. And by the fact that she had done that, I think at least 3 times reinforcing that I am not telling you, you have to do this, was her concern at the end of the day that he was making an informed decision about whether to plead. But I do agree with you, in a vacuum, that is much closer to the line. I would say this, however, the fact that this was an ex parte proceeding, I think you have to give some credit to the judge to understand that trying to get into anything related to the plea itself without the government in the room might otherwise cause serious problems. And there's nothing to suggest that Judge Teeter would otherwise do something like that under the circumstances when she moved everybody out of the room for one reason and one reason only, and that was to determine whether or not the defendant himself wanted new counsel. And again, Cano Varela talks about the issue of judges making remarks that should not force them to be trapped into a situation that would cause them to run afoul of Rule 11. And this statement that she made, as we say, we think was helpful to the defendant to inform him of making a proper decision on whether or not he wanted counsel, because you could see a situation where he returned to the court and said, I'm here to plead, and the government had withdrawn. And she said, well, you should have told me that the government could have withdrawn the plea. And, that hypothetical certainly is something that would put the defendant back on his heels and be upset about that by not being informed. So I don't think there was ill intent on the judge's part to make the statement about the government's ability to withdraw, that it was simply designed to inform him appropriately to make sure that he was going into the decision with eyes wide open.
Counsel, on the C1 issue, what do you claim this is plain error review or harmless error review?
Judge, we stand by our position that it's plain error review. I have studied this issue, and I can completely appreciate the problem that exists with the defendant trying to object to his own moving forward. It is an odd legal quirk that exists under the circumstances, but our position is, when you look at Cano Varela, actually, when you look at what this court said in Sandoval Enrique in footnote 14, that Davila instructs that we must always review a Rule 11 error either under harmless error rule or plain error rule. And when you look at Davila, what Justice Ginsburg stated on page 2149, it's very clear that it calls for either harmless error review or, in the event that the defendant doesn't object, to plain error review. So there really isn't any concern with the issue about when plain error review occurs. It's when
all that case tells us is that it's not structural error. So, right. So it's either harmless error or plain error. And why isn't it that on the facts here, where we have this, I think, a really confounding fact that's not present in all of the cases, where in addition we have this pending motion to withdraw and a conflict with counsel, that this is really not the kind of circumstance where it's fair to apply plain error review.
Again, Judge Rossman, I can certainly appreciate that position. Our position simply is, as the court has currently instructed the parties, that a failure to object results in plain error review, and that there is support from that all the way from this court to the U.S. Supreme Court. And in that circumstances, we believe that we're bound by it. Nevertheless, as we stated, we believe that even under harmless error review, under the circumstances that the judge's remarks did not otherwise cause the defendant to change his mind under the circumstances. And so we think that we win even under harmless error review. But this certainly is a vehicle for the court to clarify exactly circumstances. And I think that they're rare. I couldn't find a case directly on all fours with the facts of this case where the defendant's counsel would otherwise object to his own position. And it certainly puts that in a different posture. I see I'm out of time. I'm happy to stand for further questions.
May I ask a question?
You betcha.
On the other issue on the disclosure of the right to counsel, the B1D question, I want to assume that we say the fact the magistrate referenced this 2 years before is just too stale. And so that doesn't count. What is your view on the third prong of prejudice?
Well, Judge Murphy, I think when you take into account not only the fact that the magistrate had said that, and let's assume for the moment that it's stale, in the ex parte hearing, it wasn't as if Judge Teeter hadn't expressed to him what his options otherwise would be in the event that he decides that he wants new counsel. So it certainly was raised as to whether or not new counsel could be appointed or retained. So he did not go into the plea hearing, which occurred right after the ex parte hearing. He didn't go in with a sort of, I would argue, a question about whether or not he could otherwise get appointed counsel, because Judge Teeter had spoken with him about the possibility of appointed counsel, but that matter had to be resolved in the wake of a determination on his financial abilities. So he didn't, it wasn't something that was unknown to him.
But that sounds like an argument that there was no error. What I'm asking about is that the third prong, prejudice. If it doesn't count that the magistrate's admonition is good enough, what's your view on prejudice?
Well, I think if the court found that it was stale, we would otherwise have a difficult time trying to defend the prejudice side of this, except for the fact that the defendant, once he made the decision to enter a guilty plea, and during the colloquy in the plea hearing itself, did not suggest that he was confused about anything with respect to what his rights were to counsel. That being said, even so, let's assume we lose on the third prong. On the fourth prong, the facts here do not suggest that a miscarriage of justice would have otherwise occurred in this circumstance, because, again, he was informed during the arraignment, and he was otherwise informed by Judge Teeter during the ex parte hearing. So we think that at the end of the day, we would still prevail on the fourth prong. I'm happy to answer any other questions, but otherwise we would ask the court to affirm.
Judge Murphy, did you have any follow-up?
No, I have nothing else.
Okay, Judge Rossman, did you?
I don't, thank you.
All right, thank you, Mr. Lowellman and Mr. Magg. Well presented. This matter will be submitted. We'll go to our next case. Amy, or Kevin, sorry.
You know, we're not on the record. Oh, never mind.
Yeah.
We are.
We are.
Okay, let's see. We're ready for the next case. Ms. Shan, how do you pronounce your client's name?
I call him Mr. Cifuentes-Lopez, Rolando Cifuentes-Lopez.
Okay, we're here for United States versus Cifuentes-Lopez, and this is 24-6177. Ms. Shan, you may begin.
Good morning, Your Honors, and may it please the court. My name is Kathleen Shen, and I represent the appellant, Mr. Rolando Cifuentes-Lopez. The law in the circuit is clear. To obtain restitution under the TVPRA, the government has to prove that the defendant's offense of conviction was a but-for cause of the loss being compensated. And in a child sex trafficking case where the victim has been abused by multiple perpetrators or as a result of multiple offenses, the government has the burden of isolating the losses that were caused by the defendant's offense of conviction from other losses caused by other perpetrators or other offenses. That didn't happen here.
Well, isn't
Instead,
that precisely why the government got Ms. Wong's report, was to isolate the post-trafficking trauma losses attributable to Mr. Cifuentes-Lopez?
Your Honor, I don't think Dr. Wong's report does the work of isolating the does that work of proving but-for causation, and let me explain why. What Dr. Wong does is she first applies accounting principles to Dr. Misar's evaluation, which has nothing to do with causation. And then she does estimate the losses that were due to pre-trafficking trauma versus post-trafficking trauma. But what she doesn't do is isolate the amount of the post-trafficking losses that would not have occurred but for Mr. Cifuentes-Lopez's offenses. As she flatly testified at the restitution hearing, she could not link the amounts to his direct actions. That's in, I think, record volumes 337. She just admits she doesn't know how much of the losses that she estimated were caused by Mr. Cifuentes' offense. And, you know, she does come up with a number that she assigns to Mr. Cifuentes. But again, that number was not a calculation of how much of the losses were directly caused by Mr. Cifuentes' offense. Rather, what she does is she calculates that he's going to serve 26% of the prison time in this case, and then she says he should pay 26% of the losses. There's no attempt there.
The district court didn't adopt that.
That's correct.
That's all. So
yes, but the district.
My question is this a direct application of Anthony 1 and 2, or is this an extension? Because in Anthony, we required this disaggregation of pre-trafficking and post-trafficking trauma. It seems here where you're asking for another step, which is to isolate even further the post-trafficking trauma after it's been disaggregated from the pre-trafficking. Is this an extension of Anthony or a direct application of the case?
I don't think it's an extension, Your Honor. I think it's a direct application. To the extent that Anthony is talking about pre-trafficking and post-trafficking trauma, that's because there the different offenses are occurring sequentially, whereas here, you know, the multiple defendants are all being prosecuted at the same time. But in both circumstances, and I think Anthony 1 and 2 are clear, what has to be shown is a direct causal link between the defendant's offense of conviction and the amount of restitution being requested. And here, the pre-trafficking and post-trafficking trauma doesn't do that work because it's undisputed. It's completely open from Dr. Misar's report that the post-trafficking trauma that, or the trafficking trauma that he's calculating is an amount that results from all 4 defendants' offenses. And there is no attempt whatsoever to isolate which portion of that loss is caused by each defendant. It doesn't appear anywhere in Dr.
Is it, if I understand your argument, and I'm getting a little stuck on how 3664H fits in. So if the district court were to have done it right, in your view, it would have either discerned a direct but for a number, and then proceeded to 3664H, right? That's the sequencing that you're suggesting did not happen but should have happened. Is that right?
Your Honor, I don't think 3664H has any application in a case like this where the defendant's offense of conviction. So here, you know, 3664H is really a statute that's about a case in which you have multiple defendants whose offenses of conviction are causing the same harm. So the prototypical example would be a conspiracy, right? And if Mr. Cifuentes-Lopez had been convicted of conspiring to sex traffic these victims with their mother, the alternate theory that the government put forth. And it's assuming what's undisputed, it's the same conspiracy, then, those two defendants would be liable in restitution for all the losses resulting from that conspiracy. And they would be a but-for cause, right? There is a restitution order, they're liable. Then in that situation where you have multiple defendants who are the but-for cause of the same harm, the district court has two options. They can either hold them jointly and severally liable, or the district court has the discretion to order some defendants to pay less based on assessment of relative culpability or ability to pay. But where there isn't that shared causal, where you're not in that situation, where they're not both responsible for the same restitution loss, I think 3664H just isn't relevant. And since in this case, Mr. Cifuentes-Lopez's offense of conviction is just the single instance of patronizing the sex trafficking victims one time each, there's not really any defendant he shares his loss with. I think conceptually, you could say that if the mother had been ordered to pay the total amounts of restitution, that would, there would be a small amount that might overlap.
So just to be clear, I wasn't getting this from your brief, but I think that your response is addressing my question. Is it your position then that if you prevail on your argument that either the record and show the government didn't prove, there's an absence of but-for cause here for your client to support restitution, 3664H just is not relevant. It doesn't serve as a proxy for but-for causation, nor is it relevant here where there is not a conspiracy count.
That's right, Your Honor. I would agree with that.
Does there have to be an adjudication of guilt for conspiracy, or can relevant conduct serve as an adequate substitute?
So it's clear that it has to be based on the offense of conviction. So relevant conduct isn't part of the restitution calculation that comes from the Supreme Court.
And why is that? I don't mean to interrupt Judge Bachrach, but why is that? Why is the offense of the relevant conduct? Is it because it's not in the plea?
Your Honor, it comes from the Supreme Court's decision in Huey, which this court, applied in Mendenhall. And I think the exact language, I just want to get it right, because I think it's very helpful, is legally restitution is owed only for losses caused, and I'm quoting here, by the specific conduct that is the basis of the offense of conviction. That's this court's decision in Mendenhall, 945 Federal 3rd at 1266. And again, they're quoting the Supreme Court's decision in Huey. And I think Anthony 1 and 2 both specifically refer to the offense of conviction. So again, we're limited to the offense of conviction. To get to Judge Bachrach's question, I think it's, there could theoretically be a situation where you have conspiracy-like liability, where two defendants' offense of conviction are causing the same harm that's not charged as a conspiracy. But I think generally this is really 3664H is for the conspiracy type situation where multiple defendants' convictions cause the same harm. Does that answer your question, Your Honor?
It does. Do you mind if I ask another, or Judge Rossman, were you going to ask something?
No.
Can I ask a question? I don't want to throw you off track, Ms. Shen, but in Anthony 2, my memory was Judge Hartz wrote a dissental, saying this is an impossible burden. I mean, how in the world do you do this? You make a very compelling argument that, there's no way that a judge could look at Dr. Missar and Dr. Wong's analyses and say, okay, well, this is how much of the future treatment for these two young girls is going to be attributable to these one-time sexual, not to minimize it, they were very serious, but these, totally improper criminal sexual incidents, with these two very young girls. What could the government have presented in order to satisfy the burden at least under Anthony 2?
Your Honor, I think I've got two responses, one sort of general, and I think kind of embedded in this, your question is something I'd like to push back on, which is the fact that we have this appeal shows this is really hard. And I just don't think that's necessarily the case. I mean, Anthony 1, Anthony 2 in this case, all come from the same office and they all involve the same expert. So I don't think it's necessarily evidence that there's like a broader systemic problem with finding restitution in these cases. But to your second point, I think Anthony too, footnote 13 on page 953, it states the government could have met its burden by presenting an expert who apportioned some loss amount to the one-time abusant under a but-for causation standard, and they cite to the Human Trafficking Institute amicus that was filed in that case. And again, I'm just a lawyer. I'm not an expert in how you would estimate these damages, but I think it's, certainly conceivable that there's some methodology where you could reasonably estimate just the increased harm or the increased risk that the victim suffered as a result of this additional trauma. I would observe that there certainly is a body of scholarship about, for example, the number of adverse childhood experiences and the harms, how that increases the harms to the victim. And, I assume that there's some way, or I think at least this court can't assume there is no way to estimate that with a reasonable amount of precision sufficient to satisfy the standard.
Well, let me just play devil's advocate, but your answer is very good. But let's assume that Judge Hartz was right, that this is outside the capability of psychological expertise today. And so then if there was a satisfaction of that footnote, and let's say Dr. Missar, gave that sort of testimony, then we really would be in no different position than we are now, where a judge might say, okay, it's hard. Like you said, it's hard, but not necessarily impossible. I know what the mother did. I know what this other individual did in perpetuating the sex trafficking ring. But I, as a layperson, as a judge, can say, well, this one time, let's say with DH, this one-time sexual incident would cause, let's say, 14% of DH's future medical costs, and coupled with a deferential standard of review for factual findings. Why would that be outside the domain of a judge? If Judge Hartz is right that psychological expertise isn't at that level today.
Well, Your Honor, I don't think this court could affirm on that theory. I mean, that's exactly what was rejected in Anthony 1. What you're proposing is essentially the Paroline sort of rough division of the harm in a case where but-for cause is really impossible. And again, I don't accept that that's impossible here, but I take your question as is. I think looking at the child pornography restitution issue and how it's proceeded post Paroline, I think, Congress amended the statute to just set a statutory amount, but the statute that we have here currently provides for results for direct or but-for causation. And so both under this court's prior decisions and, just applying ordinary principles of statutory interpretation, I think but-for causation is required. And to the extent that leaves some gap, that there's a policy problem, that's up to Congress to fix.
Is there any reason that we should think that footnote 13 in Anthony 2 suggested that 3664H could be a proxy for finding a but-for causation in circumstances like this? Because it speaks about apportionment. It doesn't cite the statute or anything, but is there anything that we should be thinking more broadly about what we suggested there in terms of how the government could satisfy its burden?
Your Honor, I don't think it is talking about 3664H, even though it uses the term apportionment. I just take that as, apportionment in the general sense can refer to breaking something down into smaller pieces. If it did permit 3664H to be used as a proxy, that would eviscerate Anthony 1. I mean, it would just basically restore us to a Paroline system where you're using your sense of relative culpability as a substitute for but-for causation, and that's exactly what Anthony 1 rejects. So I don't think that.
Thank you for your answer. Do we have any cases that tell us that 3664H doesn't apply if there's not a conspiracy count?
Your Honor, I don't think there's any cases that say that, but I think it's implicit both. Otherwise, Anthony 1 would have come out differently. It just would overrule Anthony 1 to say that there's this alternative to but-for causation. And I think if you look at the restitution statutes as a whole, it just makes sense to read the loss reference in 3664H to mean the loss that is ordered in restitution, right? So and of course, any restitution order requires proof of but-for causation. So I just don't think makes sense to think about dividing up the restitution order until there's a restitution order, and any restitution order requires but-for causation. I see I'm out of time. Thank you.
Judge Rossman, did you have any additional questions?
I don't, thank you.
Judge Murphy?
No, I have not.
Okay, thank you, Ms. Shan. We'll hear from Ms. Walters.
Thank you, Your Honor. Good morning, and may it please the court. My name is Mary Walters, and I represent the United States of America in this matter. There are two issues before the court today. First, given the integral role that the defendant played in this case, did the district court clearly err in determining that he was a but-for cause of the victim's losses, and that the victims would not have incurred a subset of the aggregate losses without the defendant's conduct? There's also an issue that is foreclosed by precedent in United States versus Burns, and we agree with the defendant's acknowledgement of that foreclosure. In hearing the arguments by counsel, we did, in fact, in this case, grow from Anthony 1 and 2 and did apportion the but-for cause of the victim's losses, which were caused, at least in part, by Mr. Cifuentes-Lopez. It is clear from the record and the facts found by the court in this case that, and I'm thinking about the question about relevant conduct, while the defendant did plea to one time raping each of the victims in this sex trafficking that was going on continually with different parties throughout the trailer that the victim and the mother lived in, the victims and the mother, excuse me. He also pled, and in the documents it shows, to acts such as harboring, providing, and maintaining.
Where did he plead to that? I mean, his plea it seems pretty specific as to the two acts, and I'm be very curious if you could direct me to exactly where those words appear.
Yes, Your Honor. In the indictment itself, that is what is
that's in the charging statute.
Yes, and then
that's
when we
look at the plea agreement.
Yes, Your Honor, and looking to the plea documents, I believe there is some. And if I may back,
yeah,
yes, ma'am.
I'm not sure that that's right, but we'll certainly confirm that before assuming as much. Let me ask you a question that you started your presentation by saying we're on the clear error standard of review with respect to the evidence of but-for cause. And I was struck by a colloquy that the court had with government counsel, where the court, understandably, as Judge Bacharach's pointed out, as Judge Hartz's dissental points out, it's very difficult to prove up the loss in these cases. And the district court says, can I make a bottom line conclusion where I say, all right, even if I don't think all of these costs have been shown to meet the standard of but-for cause, surely at least some amount would, and then make that finding of restitution. And the government says, yes, Your Honor. Well, that seems to be directly contrary to what Anthony 1 and 2 require. So help me understand how this doesn't teach, this moment in the record, it doesn't teach that actually the district court agreed there wasn't evidence of but-for causation and was struggling as a legal matter with what to do about that.
Your Honor, I would say that the court did have, the court did struggle, and we all struggle because, as stated earlier in the dissent in Anthony, I believe it was Anthony 1 by Justice Hartz, this is a difficult thing to do. However, the court record and the judge in this case, the district court judge, did make a very good record about what facts led to finding that this person was a but-for cause. And in fact, defense counsel did not contest that there was some restitution owed. And in fact, the defendant would be culpable for some of that restitution. However, there was a dispute. The dispute was how much he would be culpable for. In looking to the but-for cause, we do have evidence that a but-for cause was found in this case. And looking at Bostock versus Clayton County, it is a sweeping standard, whether or not but-for causation has been found in a case.
Well, yeah, I don't know. At least for myself, I don't know that anybody questions, but-for causation, but it's how much, the future costs, I think, for me. So can I ask you a question, Ms. Walters? So based on Dr. Missar's testimony, Dr. Fong, I think, is a forensic economist. So I don't, we can include her, but I don't know that has anything to the equation. So if I'm a district judge, and let's say take DH, one of the two girls, what analysis would I go through to say, okay, from Dr. Missar's testimony or from his report, this is how much the future medical and psychological costs for DH are going to be, disaggregating what Mr. Cifuentes-Lopez did with the rape of DH versus what the mother did, what the other defendant did in perpetuating sex trafficking. How much of those medical and psychological expenses are attributable to Dr. Cifuentes-Lopez? As the district judge, what analysis do I go through to process Dr. Missar's testimony to figure that out?
Yes, Your Honor. And the reason why I know that Your Honor sounds skeptical of Ms. Wong's apportionment, or at least how she plays a part in finding what losses are attributed directly to the defendant in this case. However, Dr. Missar did an evaluation on what losses would be expected to have occurred and what losses would be expected to be in the future, psychological losses. And it's important that we find the whole of what the losses are before we decide apportionment. We can't decide who owes what until we decide what is owed.
Okay. Let's say it's $100 million. So let's say, so what percentage, as a judge figuring out restitution, I have to figure out the amount, what percentage of that $1 million true, the denominator has to be the total loss. So now, how do I do that?
As a district court judge, Your Honor?
Based
Yes.
on Dr. Missar's and Ms. Wong's testimony.
Yes, Your Honor. Finding that Dr. Missar did determine the amount of loss that would be attributable to all the trauma suffered, psychological losses of the victims. That is why the government secured the testimony and report of Ms. Wong was based on the guidance from Anthony 1 and Anthony 2. We acknowledge in Anthony 1, there was no attempt to aggregate. And in Anthony 2, the aggregation fell short in that the apportionment said that it was insufficient, that it did not identify a subset of treatment costs. So what Ms. Wong's report did was take the analysis of Dr. Missar, because as Ms. Wong stated in her testimony, she is not a psychologist. She is not there to opine on what treatment costs or what treatment would be needed. So therefore, Ms. Wong did then apportion, and as was stated earlier, the court actually, based on the record, and decided that there would be a different apportionment when pushed back.
Counsel, you keep using this word apportionment, and I must admit it confuses me, because apportionment is not relevant in the but-for universe, right? But-for cause is a standard of proof for restitution, and apportionment is relevant to 3664H. Is that would you agree with what I just said?
Yes,
Is that correct? Okay.
Yes, sure.
And so when you're saying apportionment, do you really mean that disaggregation from the whole in order to determine but-for cause for a particular defendant? Is that what you mean by using apportionment?
And I apologize. I was talking about the amount as far as after we've decided that he was a but-for cause, regarding whether or not the defendant was a but-for.
I see. Okay, that makes more sense to me. Ms. Wong was asked if she could determine, if she could link an amount to Mr. Cifuentes-Lopez's actions, and she said she could not do that. So if she was not proceeding from the point of departure of a but-for number, what do we do with whatever testimony and opinion she provided to the court?
Your Honor, as far as Ms. Wong stating that she could not link an amount, that's the issue, right? That is the issue that we run into in these cases. And she did attempt to apportion out who would owe what, and to the district court's credit, they said, look, you went off of amount of time that this person is serving and the sentence that he received. A lot goes into that you were not privy to. And then the district court took the facts relevant to what would determine Mr. Cifuentes-Lopez to be a but-for cause, and said, okay, this is how you were involved. This is what Dr. Missar said the treatment needs would be, and the cost of those treatment needs, both current and future. And then Ms. Wong said, okay, based on my analysis, this is what would be attributable to Mr. Cifuentes-Lopez. But yes, it is hard to do, and that's why we are asking the court for the guidance in these cases. And since this case was submitted on the briefs, we have the results of Coulter, which may have in fact changed the analysis even more, based on the fact that one of our minor victims had ADHD preceding being raped by Mr. Cifuentes-Lopez and by others. And based on the ruling in Coulter, that may have actually caused another wrinkle, so to speak, in determining whether or not there was an appropriate amount.
Is that why the government wants that to, should the appellate prevail? Is Coulter the reason the government is suggesting the remand should be on an open record?
Yes, Your Honor. Moving to that portion, we again acknowledge Anthony 1 and Anthony 2. No effort to determine individual liability. And then as we go forward with the ruling in Coulter, this is an area of law that is definitely quickly developing, quickly, and in a way that we would ask the court to remand with further guidance in order to allow the government to apply that guidance appropriately.
What exactly is the guidance that you think is missing?
Your Honor,
as to what question, I guess, more to ask you more specifically, what specific question would additional guidance help the government or help parties in this case in response to what specific question?
Yes, thank you, Your Honor. Well, we do have, again, Coulter was after these briefs, so we do have that additional guidance now, but also the fact that the government believes that they have met their standard. They took Dr. Missar's report, added Ms. Wong's analysis, and because this is a moving target, because psychological losses are something that is very hard to analyze and identify with exact precision, we have a situation where if we did not get it right, we would like to know why, and we would welcome any additional guidance to try to make these victims whole after being raped.
Counsel, do you agree with appellant's position that, as I've understood it, that 3664H really doesn't have anything to do with cases like this, where you only have an individual, you don't have multiple defendant conspiracy liability?
Yes, Your Honor. We originally did ask for joint and several liability, but based on our theory of the fact that this was all happening at the same time and there was some overlapping culpability, but based on looking at it as just I don't mean to minimize these two instances of raping these two children, that we would agree.
Yeah, we would agree with what that 3664H apportionment doesn't apply in cases where there's not a conspiracy count?
Oh, I apologize, Your Honor. I misunderstood. I apologize. I think it could, but I understand the appellant's argument.
Well, I just want to make sure I understand. Generally we address the arguments that the parties are making. Are you making an argument that 3664H has a bearing or not?
We did ask, I will say yes, because we asked for joint and several liability. However, I do understand the court's ruling in this case, and we are with the record that we have now,
Okay.
as far as Mr. Cifuentes-Lopez, Your Honor. I see I'm close to time. At this time, I would ask for the court to affirm the district
Well,
court's
can
rule.
I ask you one other question?
Of course,
Sorry.
Your Honor, of course.
I just thought of something connected to what we were just discussing. In the event this case gets remanded on an open record as the government seeks, and let's say that there is proof put on to establish the but-for loss for Mr. Cifuentes-Lopez. At that point, if the district court had that record and said, "Yep, I see it. This is the number. This is the restitution I've determined," would 3664H apportionment have any role to play after that initial but-for loss finding was made?
After the initial but-for loss finding was made, I think it could, Your Honor. But I would want to hear the testimony and see the record at that point.
That's fair. Thank you.
Thank you. And we would ask for this court to affirm the district court's ruling in this case.
Judge Rossman, did you have any other questions?
I don't. Thank you.
Okay, Judge Murphy?
I have none.
Kevin, did Ms. Shin have any additional time left?
No, she didn't.
Okay, thanks, Kevin. Very well presented by both sides. This matter will be submitted. Thank you.
Thank you.
Okay, we're ready for United States versus Campbell. This is 245086, and we'll hear from Mr. Lohman.
Good morning, Your Honors. May it please the court, Justin Lohman for the appellant, Kaylin Marie Campbell. I'm going to aim to reserve 2 minutes of my time. The district court in this case erred in enhancing Ms. Campbell's sentence based on 3 state court convictions entered in violation of federal law, ousting state court jurisdiction. While this court does not have a case that squarely addresses this precise issue, the governing Supreme Court precedent provides a clear answer. And I want to spend some time discussing that precedent and where this case fits within it. This case involves an application of a long-standing principle of American law, that a judgment entered by a court lacking jurisdiction is void and may not be given effect in a future case. That principle predates our nation's constitution, stretching all the way back to English common law. And as we note in our briefs, that principle has over time undergone some limitations. In 1938, in Stoll versus Gottlieb, the Supreme Court said if you previously litigated a jurisdictional determination in an earlier case, that you cannot then collaterally attack it in a later case, that principles of res judicata there apply. 2 years later, in Chico County versus Baxter State Bank, the court said that if you had the opportunity to litigate the jurisdictional issue in the prior case and you didn't, then those same principles of res judicata and collateral estoppel can apply and bar you from challenging the judgment in a later case. But crucially, on the same day that Chico County was decided, the court also cited Cobb versus Fierstein. And in that case, the court recognized that where a state court enters judgment in violation of a body of federal law preempting state court jurisdiction, that the judgment is void and may be challenged in a later case, whether the issue of jurisdiction was raised in the previous case or not, or whether it could have been. Later that same year, in United States versus U.S. Guarantee and U.S. Fidelity and Guarantee Co., the court applied that same principle again. In that case, it was a state court judgment entered without jurisdiction in violation of a tribe's sovereign immunity.
Counsel, I wanted to step back for a minute and make sure that I understood what the component parts were to your argument. So is it fair to say that to prevail, you have to show 2 things? One is that Custis would permit collateral attacks due to a lack of subject matter jurisdiction, and then 2, that McGirt is retroactive. Do you agree that you have to show both?
So I I agree with the first point. I think the second point, I don't know that that's the question the court has to reach. We're not, in this case, we're not talking about retroactive application. We're talking about whether or not this court is going to continue to give prospective effect to these judgments, which I think all sides in this case agree were entered without jurisdiction. And so if you look at Burgett, it's in that case it was a jurisdiction that was, or a judgment that was void because of the Sixth Amendment. But in that case, the court is talking about that if we don't allow for challenges in the context of this sentencing, that allows for the deprivation to be committed anew, the rights to be denied anew. And so that's the way that we see this issue, is that we're really talking here about what prospective effect we're giving to this judgment. My client is not at all trying to challenge or undo her prior sentences. She's already fully served those sentences. We're not asking for a habeas remedy where we would essentially be released from that sentence. This is all about what kind of prospective effect we're going to give to these judgments.
So is it your position then on that latter question about McGirt's retroactivity? If it's your position that that's not the question, then is it your view that our cases that have passed on whether McGirt is retroactive in the habeas context are relevant at all to our analysis here?
I don't think they are. I think when you're asking for a habeas remedy, there are different procedural bars that apply in that case because you're trying to undo something in the past. You're trying to undo a sentence that you're dealing with now. In this case, we're just talking about what is the prospective effect of these judgments. And so I do think that those cases don't bear on this issue.
Can I make sure that I fully understand your argument? So obviously, I think we're talking about the applicability or inapplicability of Hagen. And I had understood that Hagen, obviously the inverse of McGirt, is essentially saying that even if you, at least as applied here, even if you can collaterally attack these state court convictions, to the extent that you're saying, well, those were a void because the state court in each of those three instances lacked jurisdiction, that you should be able to rely on that voidness for purposes of federal sentencing now. And I thought that Hagen presented exactly, not the same, but the inverse argument that a challenge to a federal adjudication of guilt cannot be used to invalidate the effect of those prior federal convictions. So why would, assuming that we adopt your first argument under Custis, why wouldn't Hagen prevent you from prevailing on the merits, even if those three state convictions are subject to collateral challenge?
Sure. And I think this is where you have to really look at the dividing line between Chico County and Cobb, which are these two cases decided in the 1940s on the same day by the Supreme Court.
But they're not dealing with criminal convictions.
They're not dealing with criminal convictions, Your Honor, but the principles are the same.
Okay.
And so that you can find cases, in fact, Cooch from this court, the criminal case, it cites back to Chico County. Magnin versus Terrell, another criminal case, Judge Hart's in his concurrence cites to Cobb for the exact principle we're relying on here. And more broadly, the court's decision in Bigford and the court's decision again in Magnin versus Terrell, while they might not always mention these cases, they're relying back on the same kind of core principle that applies in the civil or criminal setting. But coming back to it, I think the dividing line is really illustrated by Chico County and by Cobb, because they're both in the bankruptcy context. One involved a challenge to a federal bankruptcy judgment that was entered without jurisdiction, and the other one involved a challenge to a state court judgment that was entered in violation of exclusive federal bankruptcy jurisdiction. So Chico County was the challenge to the federal judgment, and the court there said, nope, you cannot challenge this. You had the opportunity to raise it in a prior proceeding. But in Cobb, because it was a state court judgment interfering in an area where federal law preempted state court jurisdiction, the court in that case said that the collateral challenge could go forward. And that was the case whether the jurisdictional issue was raised in the previous case or not. And so Cobb is the analog to the situation we're dealing with here, with a state court judgment entered in violation of federal law. Cooch and Hagan, those fall on the Chico County side of the line. And I would just, going back to emphasize, Cobb is not the only decision that kind of takes this view. U.S. Supreme Court's decision later that same year in 1940, U.S. Fidelity, recognized the same principle. And in that case, it was a state court judgment entered without jurisdiction against an Indian tribe. And that tribe didn't raise sovereign immunity in the state court proceeding. Later on, they went to go challenge the state court judgment. And the court said that challenge could go forward because the state court entered judgment in violation of tribal sovereign immunity, which is a federal law doctrine. I do want to address some of the government's arguments about Custis. And I think it's important that we read Custis in the context in which the issue is raised to that court, and we also have to take into account the court's reasoning. After the Supreme Court decided Burgett versus Texas, a majority of circuits across the country interpreted that case as allowing a defendant in a federal criminal case to collaterally challenge his prior state convictions on any constitutional ground, jurisdictional or not. And that is, the Fourth Circuit disagreed with that. That was Custis's case. Custis took it up on appeal, and his whole argument was that Burgett should apply across the board for all constitutional violations. The government opposed that and said, no, the court should follow the traditional rule that divides between merits or jurisdiction. And that's what the Supreme Court did. The Supreme Court said the Sixth Amendment right to counsel is a unique constitutional defect precisely because it rises to the level of a jurisdictional defect. And the jurisdictional rationale is running throughout that opinion. And the Supreme Court, this court has been clear that interpreting Supreme Court precedent, the court's reasoning is just as binding on lower federal courts as its precise holding. And so we cannot divorce the jurisdictional reasoning in Custis from the court's ultimate decision.
Are you aware of any circuit decision that has understood Custis in the way that you advance here?
No, Your Honor, I'm not aware of any case addressing this one way or the other. I know that the government cited a bunch of cases in its briefs where courts have, continued to come back to Custis and say you can't use it to raise non-jurisdictional constitutional challenges. And I think they just say you can't use it for anything other than the Sixth Amendment right to counsel. I'm not aware of any other personal constitutional right that has been adjudged to be jurisdictional, but I'm not aware of any circuit cases one way or the other dealing with this precise question that we have here.
So to endorse your argument, right? Your argument proceeds under the guidelines. It's 4A 1.2 under the commentary that says this guideline and commentary do not confer upon the defendant any right to attack collaterally a prior conviction or sentence beyond any such rights otherwise recognized in law. And recognized in law means already recognized in law, right? I mean, I'm trying to understand how we can endorse your reading of Custis as coming within what 4A 1.2 permits.
Your Honor, I believe recognized in law follows from this case is just the natural progression of the reasoning in Cobb, U.S. Fidelity, and Custis and Burgett. And so we're just applying that same principle of that a state court judgment entered in violation of federal law ousting state court jurisdiction is void and can be collateral attacked. We're just applying that same principle in this setting. And so I believe that language does allow us to bring this challenge in the same way that anybody bringing a challenge on a Sixth Amendment ground, which is a recognized jurisdictional ground.
Can I follow up on this Custis issue?
Sure.
And so one question, when you say that you're not aware of any other cases dealing with this, the obvious question is, well, what about our own opinion in Garcia? And I assume that you're going to say, well, Custis and Garcia don't involve the precise situation of a prior jurisdictional defect. But if you look at the language of Garcia, it certainly seems to clearly cover the situation, doesn't it? You know, applying Custis, we hold that with the exception of collateral attack based on the complete denial of counsel, a district court sentencing a defendant under 4A12 cannot consider a collateral attack on a prior conviction. So if we say, well, we're going to interpret our precedent based on the language that is used, aren't we bound to reject your Custis argument under Garcia?
I don't think so, Your Honor, because I think you do have to read that. You have to read the court's decision and holding in light of the issue that was presented. And there was no argument about jurisdiction in that case. It's undisputed that the challenges that were raised in that case were non-jurisdictional challenges. And so to read the court's comments on that point as just extinguishing any sort of jurisdictional challenge, despite Custis's reasoning, I think is an overbroad reading of the decision.
Okay. I don't want to monopolize the time, but let me ask you one other question. So my memory, it may be wrong, is Justice Gorsuch and McGirt, credited the continued existence of procedural impediments and said, this is not to say that we're opening the avenue under McGirt, for the interim, period of these 18 months or whatever. But under your argument, when we're all dead and our grandchildren are having kids that are occupying the 10th Circuit or whoever 150 years from now, I could say the future mentees of Mr. Lohman saying, back in the 21st century, we have this precedent that Judge Rossman, Murphy, and Bacharach created to say that there is no time limit. Your criminal history, was 100 years ago, but that's fair game because that was in Tulsa, and that was that state court conviction was null and void. Boy, talk about opening the floodgates. When we talk about opening up criminal history, enhancements, 4A12, and this is a revolutionary argument that you're making, isn't it?
Your Honor, to come back to the point you made at the beginning with Justice Gorsuch noting these procedural bars that apply, my argument is not against any of those. When we're talking about a retrospective remedy where you're trying to undo your sentence, a habeas remedy, those protections still apply. In that setting, you still have to bring the state officer who's holding you in custody before the court. You have to go through that process. There are procedural protections there. We're just talking about the prospective effects, whether we're going to continue to give prospective effects to a judgment that
may have happened 50 years ago. Right.
That's correct. But we're talking here in a case where we're dealing with a judgment that all sides acknowledge was entered without jurisdiction. And so the question is, it's just a perspective issue, is whether we're going to deny these rights anew, to use Burgett's language.
Okay.
But doesn't your perspective effects argument depend on the retroactive application of McGirt?
I don't think so, Your Honor, because retroactive application is tied in with the habeas statute, tied in with habeas relief, which again, when you're trying to undo a sentence, trying to undo some sort of relief that's retroactive, those principles come into play. But I think there is a certain divide here with this perspective versus retroactive.
Judge Rossman, did you have any other questions?
I don't, thank you.
Judge Murphy, did you?
No, I don't.
All right. Sorry to steal so much of your time, Mr. Lohman. Mr. Bryden.
May it please the court, Stephen Bryden on behalf of the United States. And if I could, Your Honor, I'd like to start off where both Judges Bacharach and Judge Rossman were just discussing with my friend on the other side. First, I'd like to point out that not just Justice Gorsuch in the majority opinion in McGirt, but also the primary dissent authored by Justice Roberts, which would be all 9 justices signed on between the two, made a specific point to discuss these procedural obstacles that the state had weighed for the purpose of McGirt that would likely keep these convictions from being found void in further situations, in the state of Oklahoma. And that's important because if Mr. Lallman is correct on this argument, then all of that is superfluous, right? If the law is because these convictions were rendered without jurisdiction after the McGirt decision, that there was no reason to do a procedural analysis under Oklahoma law, then all of that was something that was unnecessary to add to the opinion, and that's generally not how we read Supreme Court opinions. And then also something that you touched on, Judge Bachrach, about what this effect would be on the state of the law. Well, that's something that Couch considered. It was a big part of why the Couch case after the Hagen case came out the way it did, which is that basically retroactively saying none of these convictions count in the state of Utah after they redefined what was or wasn't Indian Territory would result in an 18-year, they called ex post facto lawless zone, where these convictions just don't matter. Well, doing that in this case would create a 100-year ex post facto lawless zone because the state of Oklahoma for 100 years has been prosecuting criminal cases believing that it had jurisdiction. Couch also, in its discussion of the equities, talks about the fact that when a defendant basically subjects themselves to the jurisdiction, they plead guilty, they accept responsibility for those offenses. Those are things that a court should consider as weighing against a need to retroactively eliminate those convictions. And that's the case here. Ms. Campbell pled guilty in all of these cases. She did not assert any kind of jurisdictional defense, nor does she assert any kind of defense that there was something procedurally wrong that led to a deprivation of her rights other than the venue of prosecution in this case. And that's something that the Couch court found was important. Another distinction I think is important to make is between the civil cases that Ms. Campbell relies on, specifically Cobb and Checote and the cases just discussed. It is important that there are cases involving civil judgments and not criminal convictions. This court in the Mayfield case in 1987 said about as clear as it can, the issue of whether a court has proper jurisdiction is a legal one, and hence no conviction is void from inception for lack of jurisdiction until a court with review authority has so declared. Whatever the law may be regarding the effect of civil judgments or default civil judgments, the law on how this court should treat criminal convictions is clear. They're void until reviewed by a court that's tasked with actually reviewing them. So in a 2255 situation or some other place where the court has the ability to question the conclusiveness of those convictions. I also reject the idea that there's a really strong.
Can I test that? How far that goes? Let's say there's a fraud on the court that's not discovered until many years later. Let's say Mr. Campbell is challenging the use of one of the convictions that was, let's say, took place in state court, and he's not making a McGirt type challenge, but he's saying, I have just learned that that the lead investigator in that case has been convicted of fraud. We've seen high profile cases involving forensic chemists and the like over the years. What if that had not been previously recognized and adjudicated as an invalidation of that prior conviction? Can someone come forward and say, well, there's been no prior recognition of the invalidity of that prior criminal conviction, but that's only because the court was the victim of fraud?
No, they couldn't, Your Honor. Now, certainly in the case of conviction, they may have remedies under 2255 or some other statute. But part of the reasoning of Custis about what makes the complete deprivation of counsel so unique, it was two parts. One was how serious it is in terms of the defendant's ability to exercise any of the rest of their rights. But the second part was how clearly it can be proven on the face of the documents. And so being able to tell if there's a complete deprivation of counsel is easy. There's either counsel entered or there's not. In your question, trying to determine whether there was actually a fraud on the court in that scenario would require significant testimony, likely expert testimony and things like that. Likewise, the issue here, again, is not as simple as simply looking at a document to determine whether these convictions from the state of Oklahoma are valid or not. This court, over the last 6 to 12 months, has had a number of cases about the level of proof and the difficulty of proof in showing Indian and non-Indian status. To actually adjudicate whether these convictions are valid, there'd have to be a proof of actual Indian status at the time of the offense. There would have to be proof that it occurred within Indian country, and that it doesn't fall into any kind of exception that fit into that situation. And so that second important reason in Custis that they separated Sixth Amendment complete deprivation from everything else, it doesn't apply to your hypothetical, nor does it apply to the situation here.
Thanks.
But in Custis, Custis said that the complete deprivation of the right to counsel is so significant because it rises to the level of a jurisdictional defect. And here we have literally the argument is a jurisdictional defect. So doesn't the logic of Custis here just compel us to endorse the appellant's argument? I mean, we don't have something that's like a jurisdictional problem. We have literally a jurisdictional problem.
Your Honor, while I recognize that that is the quote from Custis, Custis also specifically says that the only exception that is considered is complete deprivation of counsel. And if what the Supreme Court meant was the only exceptions are complete deprivation of counsel or issues of subject matter jurisdiction, they easily could have said so. And to understand why they would say it rises to the level of jurisdictional defect, but that might not be justiciable in this situation, is because of the second half of what's important about that concern. The court acknowledges when they were looking at, how bad does the deprivation of counsel have to be? I mean, you could have such an ineffective counsel that they're not able to actually defend any of your rights. And so it would be practically the same as having no counsel at all. But practically the same as having no counsel at all does not let you file a claim, a collateral attack under Custis, because proving that would require a significant amount of proof where that new collateral court is having to review things that would be best reviewed by the original court. And it's the same with matters of jurisdiction here. If a district court was to sit on the validity of this conviction right now, not only would it have to discuss what I just talked with Judge Bachrach, would also have to walk through the procedural defenses that were discussed in McGirt about how Oklahoma's statutes would apply, how res judicata or lashes or equity, any of those things could apply on whether or not the conviction is void or not. I recognize that Ms. Campbell made an argument that the validity of the underlying conviction may not matter and that they're only arguing about a prospective use here. But as Judge Rossman discussed earlier, we're operating under a guidelines provision here. And the guidelines provision says to count convictions unless they've been rendered void by another court, or if they've been given in complete deprivation of counsel. And so, essentially they're asking for a remedy in equity that goes beyond what's allowed by the guidelines to say, yes, there are situations where my conviction might not be legally void, but it would be unfair to give it to me going forward. And that's just not what's contemplated by that guidelines provision, and it's not what's contemplated by Custis. If the court has no further questions for me, I would ask that this court affirm the decision of the district court, and I would yield the remainder of my time.
Judge Rossman or Judge Murphy, do you have questions?
I have none.
Okay. Kevin, did I unintentionally cheat Mr. Logan out of all his rebuttal time?
Judge, he went 2 minutes over.
In other words, yes, sorry about that, Mr. Wall. It's very well presented in any event by both sides. This matter will be submitted. Thank you both.
Thank you.
Good morning. We are here on United States versus Arnett, and this is 2462-12, and we'll start with Mr. Lee.
Good morning, Your Honors. I'm Josh Lee from the Colorado Federal Public Defender's Office, and I represent Mr. Arnett. This appeal challenges the sentencing court's imposition of a 4-point enhancement that applies when a firearm defendant has also committed another felony. So I've raised 2 plain error arguments against this enhancement, and I'm going to start with the first one today. And that's my argument that Mr. Arnett's alleged possession of marijuana was just a misdemeanor and not a felony. So possession of marijuana is a felony if the defendant has a prior conviction for a drug, narcotic, or chemical offense. And whether Mr. Arnett has a prior drug, narcotic, or chemical offense boils down to whether Section 844C's definition of that term is applied using a factual or categorical approach. Both the plain text of 844C and this court's binding precedent require the categorical approach.
Counsel, let me ask you a question about your plain error framework. Even if you could show error, you have some plainness problems, I think. And my question really goes to your reliance on Martinez, Hernandez, Herrera, Roldan. So you have the plain language of the statute argument, but you're also relying on those cases, and the use of the word prohibits is essentially the same as proscribes. Can you speak to why we should endorse that view of plainness?
Yes. So in terms of the prohibits being the same as prescribes, I believe that this court has prior plain error decisions, for example, Venjon, that says a decision about one statute can be clearly generalizable to another statute and therefore render an interpretation of that statute, the second statute, plain. And that's what we have here. So in Martinez, Hernandez, and Herrera, Roldan, this court confronted two statutes that defined a predicate offense as one that prohibited certain behavior. And this court said, well, the word prohibits obviously directs us to the statute of conviction. And so here we have a statute that says a predicate offense is one that prescribes behavior. Prescribes is just a synonym for prohibits. It directs us to the statute of conviction in exactly the same way. It's clearly the prior decisions, because prescribes just means prohibits, are clearly generalizable to this new statute and therefore render the error plain. But to be frank, it would be plain even absent Martinez, Hernandez, and Herrera, Roldan, just based on the plain text of the statute. So this court has prior decisions such as the Jones case that I've cited in my brief that says the language of the statute itself can render an error plain. And just as a matter, so we've got one of two things. We're either looking to the facts or we're looking to the statute of conviction. And just as a matter of plain language, facts cannot prescribe anything. Only the criminal statute can prescribe something. So, if you tried to apply the factual approach to this statute, it wouldn't make any sense. So if we say, all right, Mr. Arnett, as a matter of fact, previously possessed cocaine, does his possession of cocaine prescribe the possession or trafficking of a controlled substance? It doesn't. That's just not good English to say that. And I think that that's what Martinez, Hernandez, and Herrera, Roldan recognize.
Mr. Lee, can I ask you, on plainness, you make a very, I think, a very persuasive argument if we were addressing this in the first instance. But if we are, to be looking at whether it is an obvious error, candidly, how did the three of us say? I mean, when you had Judge Matheson's unpublished opinion, I thought you had a good argument. Well, Judge Matheson wasn't confronted, with this argument. You cited a case saying that, well, I mean, it was unpublished and the argument hadn't been presented. And then in Simmons, your office presented exactly the same argument, and a different panel said exactly the same thing as Judge Matheson's panel. So now we have 6 judges in our court that said it's not only not obvious to them that you're right, but they disagree with you. So how do we say, well, Mr. Lee is obviously right, and our 6 colleagues who looked at, well, 3 of which looked at exactly the same argument and said they are obviously wrong. It's sort of like crediting an argument when there was not a certificate of appealability. I mean, it's odd.
Quick quibble with your question. So I think my response on Shaw, right? That it didn't have it before them.
Right.
All right. On Simmons, it's important that that case itself was decided on plain error review. So I don't need to show that Simmons is clearly or obviously wrong. I just need to show that.
No,
I just need to show that it was wrong, right?
Judge,
that it was.
But I keep doing it. I'm sorry, Mr. Lee. So I apologize to you. Forgive me. But
oh yeah,
am I wrong that Judge Timkovich said not only is it that it maybe it's dicta, but he said it's not error. The categorical approach applies.
No, he said that it's not plain. Judge Timkovich ultimately said it's not plain that the categorical approach applies. But regardless, Simmons actually has the exact same problem that Shaw does, in that it just does not confront the existence of 844C or the fact that it defines a predicate offense as one that proscribes behavior. We're looking at unpublished decisions for whether they're persuasive, and it just does not give any basis for reading prescribes in any other way than what I'm reading it.
Does Simmons give us anything that Shaw doesn't give us? Does Simmons build entirely off of Shaw?
Simmons does build entirely off of Shaw. I think what we would be looking for in terms of persuasive authority would be some alternative way of reading section 844C. Simmons doesn't cite or quote 844C, doesn't give us any alternative way to read it, or some way to distinguish a prohibit statute from a proscribed statute. And Simmons doesn't say anything about that either. So
but it does say Simmons' arguments analogizing 844 to seemingly parallel statutes is thus unconvincing. I don't disagree with you that he didn't address, at least textually, your argument, but he does say that the argument presented by your colleague is unconvincing.
So, well, I'll just say that I orally argued that case, so I can't blame it on the colleague. I orally argued Simmons, so I'll take responsibility for that, for not presenting it clearly enough. That said, this is where I think that Simmons goes wrong on the plainness analysis. So what Simmons says is, hey, those were about different statutes. Like, they can't show it's plain because those were about different statutes. But that's contrary to what this court has said about plain error review. And Simmons did not undertake to say, are these prohibits cases clearly generalizable to 844C? And it went wrong in not undertaking that step. And they are clearly generalizable to 844C. So I think you sort of have, there are the problems with Shaw and Simmons that render them not persuasive, but you also have these prohibits cases are binding. They're not distinguishable from this case. And if you have binding precedential authority that you must follow, it sort of renders non-binding persuasive authority immaterial. So I really think the order of operations should be, do we have binding precedent that requires this outcome? And from my perspective, we do. These prohibits cases are just binding and indistinguishable. And if that's the case, these persuasive, ostensibly persuasive authorities just are not of any moment.
That proposition, however, was not plain to the panel in Simmons, correct? What you just said.
That's right. And I just think that it's Simmons's plainness analysis itself is not binding and is helpful to the court only to the extent that it's persuasive, and it's not persuasive for the reasons that I said. They don't offer any reasons to suppose that the words prescribes can be read to permit a factual approach, and they don't offer any basis or any cognizable basis to distinguish Martinez, Hernandez, and Herrera Roldan.
Let me ask this:
so-
if we agree with you, would we basically be saying that the panel in Simmons were plainly wrong?
Not in Shaw. In Shaw, yes, you would have to say the panel was plainly wrong because they did not have the arguments before them. Simmons itself was decided on plainness grounds. So I think you just have to say that Simmons conducted its plainness analysis incorrectly because it didn't. You don't have to say plainly incorrectly. They conducted it incorrectly by not recognizing that the text of the statute itself or prior decisions clearly generalizable to this one can make an error plain. I also think it's important to say that it's not a subjective test. The Supreme Court has told us plain error review is not a grading system for judges. And this court has said in McCarr that, to err is human and to plainly err is also. So I think it's really more just an objective analysis, and there's no need to cast aspersions on prior panels just to say that, one of them didn't have the arguments before them and the other one, we disagree with how they conducted their plainness analysis. I think that's the consequence of having unpublished decisions that aren't binding and those being in conflict with published precedential decisions. Unless there are further questions, I'll reserve the remainder of my time.
Judge Bacharach,
I do.
you're muted. Judge Bacharach, I believe you're muted.
Oh, thank you.
Sorry, Judge Murphy, did you have something to ask?
I did. On the the question of constructive possession.
Right, the second issue.
Yeah, as I understand it, the drugs, even though the defendant said, "Oh, I have drugs in my car," they were sitting on the seat next to him, right?
Yes, right, in a closed bag. Yes.
And this is immediately after they had observed people coming and going out of the club to
that didn't happen. I didn't quibble with that in the government's answer brief because I don't think it's material to whether the judge applied the wrong standard, but it was pretty clearly established at trial that the police officer was wrong about the people coming and going. He had written in his report that he couldn't see that, and said for the first time at trial in contradiction to what he'd said in his report that he saw that.
well, is that just a given that it didn't happen?
I think it was pretty well established at trial through impeachment that it didn't, but regardless, the jury acquitted him of intent to distribute the drugs. So, and the judge didn't rely on that.
Right, but that doesn't mean that they also said he did not possess them. And that's the serious question. Correct.
Right, I agree with that. I think it's a question for the district court applying the correct standard. So the problem is we're not saying that the judge couldn't find that he possessed under the correct standard. We're saying the judge didn't find that he possessed under the correct standard.
Okay, so you're saying that there are sufficient facts from which you could infer possession and intent to possess. It's just that the district court did not make that finding.
Exactly.
Okay.
Well, counsel, if that's your position, how do you get over the third prong of plain error?
So the third prong is not a sufficiency analysis. So the fact that the judge could find intent to possess and that it wouldn't be reversible clear error on appeal doesn't mean that the judge would make that finding. There's a reasonable probability that the judge wouldn't make that finding for all the reasons that I've laid out in my brief. It was his girlfriend's car. His girlfriend said it was her marijuana. The judge never said that he didn't find her credible on that, etc.
But even if it's not a sufficiency analysis, don't we discern whether you meet your burden to show a reasonable probability by what the evidence showed?
Yes, and I think that the evidence very strongly suggested that there was no intent to possess. I don't know that we would have like a clear error finding, but I feel pretty confident that by a preponderance of the evidence that there was no intent to possess. And I think that that's what the judge would find on remand.
Is there any evidence, as I understand it was in July, that she acquired the drugs, and sometime between then and February of the next year, she decided she didn't really like those drugs. Do we know when the latter occurred? That she kind of disclaimed the drugs because she didn't like them. Do we know, is there any way to measure in the record when that occurred?
No, what I do know is that there was a whole bunch of garbage in the car, not just this. And she testified like, look, this was just trash that I needed to throw out and hadn't, like all the other trash in my car. You know, it kind of looked like my car, I guess.
All right. Is there in the record pictures of the inside of the vehicle?
Yes, there's body camera footage that shows the inside of the vehicle and all of the trash that was all over the car.
Okay.
That's in the record on appeal. Again, though, I do think that these are all things for the district court to assess, and that there's plenty of evidence to say there's a reasonable probability that the judge might not find intent to possess. And that's based on it was his girlfriend's car. It was her marijuana. That she said that he never had anything to do with the marijuana. The judge never suggested that he didn't find her testimony credible. And so it's just, I think, if you reach issue 2, which I don't think you should, it's just a remand to the district court for him to apply the right standard.
Thank you.
Judge Rossman, did you have any questions?
No, thank you.
All right, thank you. Give me 1 second. Okay, we'll hear from Mr. Bond.
May it please the court, Cedric Bond on behalf of the United States. I'd like to start first with this question of constructive possession. And in the court's analysis of that at the sentencing hearing, the court referred back to the testimony at trial, showing that that was established possession of this constructive possession of the marijuana. And that's very relevant here on the question of whether there was an error at all. Because at trial, the pattern jury instruction for constructive possession was what was presented to the jury. And so that is the presumption that the court applies the law correctly here is strengthened by the fact that the court was actually referring to the context where that proper standard had been applied when it concluded.
But wait a minute. The court was really talking about the evidence in the trial, not hearkening back to the jury instruction. So what was there about the evidence that would make it clear that he possessed these drugs and that he intended to do so?
Yes, Your Honor. I think that is that, as the district court said, there's ample evidence from the trial that did so. We have officers approaching a vehicle, and as they approach, they testify that it smelled strongly of marijuana. They arrive, they find the firearm under the man, and he admits immediately that there's marijuana in the car. They confirm that. They find it within an arm's reach of him, in a paper bag on the seat, and in a Walmart grocery sack on the floor. And this is in the testimony, pages 269 of the volume 1 through 277. And also, this point wasn't actually addressed at in the sentencing hearing, other than the inference back or reference back to the testimony at trial. But there was testimony that there was actually marijuana on the firearm itself, which is a very close nexus between the firearm and the marijuana. In fact, as approximately close as possible. And looking at some of the cases that the court applies in this standard under the proper intent to control standard, Little is a great example. Although in that context, there was actually the wrong standard that was given to the jury, and we're actually talking in which makes the point that this is actually a beyond a reasonable doubt question in that case, rather than the preponderance finding that we're just reviewing here. And there, the court then said that intent to control can be inferred from the circumstances. And in that case, even though the wrong standard was given to the jury, they found that standard was harmless. This court found that was harmless, given the totality of the circumstances there, and noting the exclusive control of the person in what was there was a well house, a small little structure, and the person defendant had exclusive control of it, had been in there.
If you're addressing my question, my concern is not about the confugality with the jury instruction and the wrong citation and the sentencing memorandum. My concern is what evidence at trial was the district court referring to when it said harken back to the trial? I'm talking about evidence, not this jury instruction stuff.
Yes, Your Honor.
And if you've already explained it, don't use any more of your time.
Okay. Well, I would say that testimony that I referenced there is that evidence there. And then at the sentencing hearing, the court really pointed to Mr. Arnett's knowledge of it and the close proximity of it to him. And I think those right there provide the permissible inference that is all that is necessary for this intent to control, and that should resolve that question for the court here, particularly. Yes.
I'm sorry. Please finish your answer.
Yeah, particularly under the plain error review of a preponderance finding. Yes, Your Honor.
Turning to the 844C argument, do you agree that Sean Simmons just did not have occasion to pass on the argument that the appellant presents here?
I would not agree with that. The plain text of 844 has both this term and its definition. And so I would say it was before the court in Shaw. The court had that, the pro se appellant there did present this argument, claiming that the categorical approach should apply, which is enough for this court to review not just the statutory prohibition, but its definition as well.
Okay, so let's assume that the court had in front of it 844 all of 844 and the definition, even though I don't think the case really talks about C. Let's just spot that the statute, that the appellant's argument here on the face of the statute may have been before the court in Shaw. But this argument about understanding and generalizing from our case law that talks about proscribes or prohibits to proscribes, that argument wasn't before the court in Shaw, right?
I don't believe that. I don't recall whether it was before the court in Shaw. It was before the court in Simmons, and I'll note that the court in Simmons did find that the Herrera-Roldan case was distinguishable and did not dictate the outcome there. That is the right interpretation, because both Herrera-Roldan and the Martinez-Hernandez case made that tie of the prohibits to the categorical approach at the conclusion of their analysis of the text and context of that particular statutory prohibition or provision. And so I think that, that's not some, shibboleth that has to be there. And if it's there, it automatically makes it, requires the categorical approach. This still requires this complex statutory interpretation and analysis of the full context of this statute, A and C, and their interactions together.
But how can the word, just as a matter of common sense, how can the word proscribes implicate a factual approach?
The way I would look at this statute, if we were working off of a blank slate here, is that this prohibition in 844A is where you'd have to start before you get to 844C, and that's except if he commits the instant offense after a prior conviction for any drug, narcotic, or chemical offense chargeable under the law of any state, and thereby just drawing in all 50 states drug, chemical, or drug, narcotic, or chemical offenses, and then there we move to the definition, and
okay,
it's equally as broad.
Mr. Bond, can I stop you? I don't want to interrupt you, but I want to make sure I'm following you, and I think I may have lost you. So what is it in 844A that you're hanging your hat on before we get to C? I
think in 844A, we have both this broader, this term that's broader than any that I've encountered in the categorical approach analysis, this drug, narcotic, or chemical offense term, which is a broad term in and of itself. Then the chargeable under the law of any state, that itself expands this. And then we move to the definition, where it means any offense, which prescribes the possession of any substance that's within the Controlled Substances Act. And so I think that that's right where we get into this factual approach, that we have to look at whether, as the court indicated in Simmons, whether this was actually there was methamphetamine and offenses, and here we have marijuana, cocaine offenses. And that's, I would argue, that is consistent with the statutory language, or at a minimum, it's not plain from that statutory language that has to require. And I think, as the court, the panel's questions earlier indicated, plainness really is the dispositive issue for this appeal. And I think it is the appropriate issue for the court to decide this one on, because in one last thing, as far as the error, this is a substantive felony that we're talking about. It is before the court here in a plain error sentencing context, where it has been used by the guidelines. But applying the categorical approach to this pre-trial, pre-conviction setting of this felony offense here I don't believe would be consistent with the intent of Congress, as indicated by the statutory reach of all the states. But also, it doesn't have the Sixth Amendment concerns that that applied in Descamp, and as indicated by the court's Davis decision, where it talks about on page 454, it discusses the pre-conviction context, and that doesn't raise those same concerns. And also in the Nijuan case, where there was the question about, well, if this is defined as an aggravated felony, how does that apply in the enhancement in 1326 for aggravated felonies? And the Supreme Court found no constitutional issue with that, because the government would have to prove beyond a reasonable doubt that it met the necessary prerequisites there, the $10,000 threshold. So that goes into the reason to be cautious about approaching the plainness or the error question here. And the plainness is where it works best here. And it's very, the court would be hard pressed to find plainness here, where two panels of this court have not found it, with this presented with the same, or I would argue the same arguments. And
Mr. Bond, can I ask you about that? And I don't disagree. I mean, I don't think Mr. Lee would probably disagree. It is a little of a challenge for the defendant, to say something is obviously wrong when you have two panels, whether they evaluate it under plain error or as preserved error. But to just follow up on what you said, and to follow up on Judge Rossman's question, and forgive me if you've already answered this, but because I do understand, I think you're presenting a very good global argument based on A and C under 844. But if we narrow down just these three words, and maybe I shouldn't be taking these three words in isolation, offense which prescribes X. I really, ever since I saw this case, I've been trying to figure out, well, what is the response to Mr. Lee's argument? Why did Judge Timkovich in that panel in Simmons find this argument unconvincing? I understand why Judge Matheson may not have, because the argument wasn't presented. But how can, like Judge Rossman says, how can an offense which prescribes be reasonably interpreted, or even conceivably interpreted, to require us to look at the facts? An offense either prescribes something or it doesn't.
I think that I don't think that when Congress passed this act, they were anticipating the categorical approach to apply. I think that's very clear.
Totally true. Yeah.
And it's also clear that they intended for this to apply to any state. And I think that that is probably some of that, plus the just overall breadth of this definition relative to the other controlled substance related offenses that have applied or have been applied. I think that is enough to show that those prohibits cases are distinguishable in this context. And I see I'm almost out of time.
I had one follow-up question. If the categorical approach does apply here, does the government agree that Mr. Arnett lacks a qualifying predicate?
The government did not challenge that. I believe that Cantu would probably be dispositive there.
Thank you.
Judge Rossman or Judge Murphy, do you have any other questions?
I don't.
All right. Thank you, Mr. Lee. I apologize to you as well. It didn't do it on purpose, but I deprived you of your rebuttal time. But it was very well presented by both sides. Thank you both. This matter is submitted.
Thank you.
Okay, we're here on United States versus Robbins. This is 24-7067, and we'll start with Ms. Shen. Thank you.
Good morning, Your Honors, and may it please the court. Again, I'm Kathleen Shen, and I represent the appellant, Mr. Tion Robbins. The order denying the suppression motion should be reversed. Although the district court was right that there was a Rodriguez moment after Trooper Koch received the rental agreement, it was wrong that the subsequent dog sniff was justified by reasonable suspicion. The only factor that the district court relied on to find reasonable suspicion was this, that Williams told police after a pause that they had been to Yukon, Oklahoma, whereas Mr. Robbins told police that they had been to California, New Mexico, and Arizona. That is not enough for reasonable suspicion.
Oh, go ahead, Judge
No,
Robbins.
please, Judge Bacharach, go ahead.
No, you go ahead.
Okay. Counsel, I'm trying to understand what we're supposed to look at to review, to do our de novo review of the ultimate Fourth Amendment question here. And to that end, I'm struggling to better understand how the district court's credibility determinations factor into our review, because typically, even if the court narrowed its focus on our de novo review of the inquiry, if there are other facts presented in the totality that would support reasonable suspicion, those wouldn't be off limits to us to review for the ultimate Fourth Amendment question. But here, it feels to me like we may be limited because of the district court's emphasis on how it read or how it understood Trooper Koch's credibility, how it made a credibility determination with respect to Trooper Koch. So if I'm being clear about my question, how do we think about the district court's consideration of the trooper's credibility in our analysis of the Fourth Amendment question?
Your Honor, I understand the question. And I think the negative determination about Trooper Koch's credibility is a factual determination that this court defers to. The government hasn't argued that that determination is clearly erroneous, and I think with good reason. I mean, that's basically an unreviewable finding that Trooper Koch's testimony wasn't reliable, and the district court himself was careful to say that he was relying only on the video to find that these statements were made because he wasn't relying on Koch's testimony. It's true that this court is on de novo review, and so that does give it a little bit more leeway, but I still think party presentation principles matter as far as what factors this court considers in assessing whether reasonable suspicion exists. And, I'd point this court to, for example, in Lopez, there are factors in the record that the court doesn't consider because they weren't presented by the parties or considered by the district court. And so I think in this case, it's very clear that the district court only relied on the inconsistency in the statements. And this court has never found reasonable suspicion based on these kinds of inconsistent statements alone. On the contrary, go ahead.
Could an inconsistency in travel plans ever create reasonable suspicion?
Your Honor, I think that because reasonable suspicion is fact-bound, I'm not going to say that there's no inconsistency that could never, that would ever support. Maybe there could be a lie that's so egregious. But I think in this case, and with this kind of relatively minor inconsistency, I think this case is this is never going to support reasonable suspicion. And justice.
No, you go ahead. Sorry.
And, to begin with, I don't even think these statements are inconsistent. Again, it could be true that you stopped in Yukon on the way back from a longer trip that involved California, New Mexico, and Arizona. And that's especially true when you take the context that the statements were made into account. Williams gave this response about being in Oklahoma or in Yukon as part of a conversation where Koch asked him, "How are y'all doing today?" And then Robbins, on the other hand,
I'm sorry, I keep talking over you, Mr. Yen, but don't we have to? And I realize this isn't a popular view among the defense bar, but we do have precedent saying that that we do have to view the evidence in the light most favorable to the ruling, right? And so if there are circumstances in which an inconsistency in travel plans, and I think we can all imagine. I say I'm traveling with Judge Murphy, and we get stopped in Yukon, Oklahoma, and the policeman stops me and I say, well, we started in California. We were going to Maine for a football game. And Judge Murphy says, no, we actually started in Portland and we were going to Florida to see a Miami Heat game. Well, those are such extreme examples that I think anybody would say, well, that's very suspicious. And here, maybe it's not as extreme, but we do have to view the evidence in the light most favorable to the ruling, don't we?
Your Honor, I don't think the light most favorable to the ruling language really does any work. I mean, the Supreme Court's clear in Ornelas that the ultimate determination of reasonableness or reasonable suspicion is a legal conclusion that this court makes. My theory about the light most reasonable language is if it's in conflict with Ornelas, it's wrong. And on the alternative, it could just be an expression of the clear error standard, but we're not challenging the district court's factual finding that these statements were made. And I think it's actually really notable that if you read the district court's order, he's not even finding that these statements are very suspicious. He says, if I were writing on a blank slate, I'd be inclined to agree that these statements aren't that suspicious.
But he does, but the inconsistency is a factual finding, isn't it?
Your Honor, I don't think it is, but regardless, under either standard, this court can look at the statements and the context in which they were made to determine whether they're inconsistent or whether they rise to reasonable suspicion. And as an example, I would point this court to its decision in Leon, where it actually does review the district court's finding that inconsistent statements were made. There, the defendant had made multiple statements that he was from Arizona, that he was transitioning to Minnesota, and this court on appeal looked at those statements and said they're not actually inconsistent. So I think it's clear that this court can make its own judgment, both about whether these statements are inconsistent, but even accepting that they're inconsistent, this court can conclude, and I think should conclude, that they don't rise to the level of reasonable suspicion. And that's because, as this court has recognized, there are just so many reasons why innocent travelers might make statements that are different along these lines. They could be tired, they could be distracted, they could be on the phone with somebody else, or they could just be really private people. As this court said in Santos, many motorists, even innocent ones, just don't think their travel plans are any of the troopers' business. And, reasonable suspicion requires that the articulated factors together, and here we have just one factor, but taking everything into account, it requires—
Well, counsel, can I stop you for a second? I want to really drill down on my question because I'm still a little confounded about how to treat the credibility determination in terms of defining the universe of factors that are relevant to reasonable suspicion. So in getting to this place where it's, a totality of one, so to speak, right, where it's just the inconsistent statements, the other factors that the district court recounted in reviewing the magistrate judge's reasoning were the nervousness, right? And then the over politeness, gym bags, the dashboard photo, and then these inconsistencies, right? Is it your position that we should attribute the rejection of the nervousness, the politeness, the gym bags, the photo on the dashboard, all as a function of rejecting Trooper Cox's credibility and sort of deal with it that way? Or is really only the nervousness attendant to the credibility determination?
I think that the credibility determination does have some relevance as far as the idea that some deference is owed to a police officer's testimony about what is suspicious. I don't think any deference is owed to Trooper Koch in this case because the district court found that his testimony was not consistent with the video evidence, and it was within the district court's discretion to choose not to credit his other testimony about, for example, the photograph being suspicious or politeness being suspicious. I also don't know that it's necessary for this court to get here because I just think even taken on their own, those factors simply are not suspicious, and I'm happy to address them if this court has any questions. But I think whether it's because of the judge's credibility determination or because they're simply not suspicious, those other factors don't matter, and I don't think need to be addressed by this court.
All the factors that have been mentioned so far exclude the factor of the rental agreement. Now, in some of the cases, there's a suggestion that the fact that there's a rental vehicle is one of the little items you put on the scale reasonable articulable suspicion. The consideration of the rental status here is even different than that. I mean, if you look at the transcript and the recross examination of the trooper, it's very clear that until the other officer brought the physical evidence of a rental agreement, it was uncertain whether there was a rental agreement. It was uncertain whether these people were properly using the rented car. Now, none of the questions have addressed that. So that's a factor, it seems to me, that exists that the magistrate judge didn't talk about that being dubious. The district judge didn't talk about that being dubious. And if you have that factor, along with some inconsistencies in travel plans, under our case law, isn't that just in and of itself enough to say that, given all those circumstances, we have to affirm?
No, Your Honor, and I think for several reasons. First, by the time the dog sniff occurred, and I think this is clear from the record, the rental agreement had been produced. And so there, to the extent that an outstanding rental agreement could raise a question about whether they're lawfully operating the vehicle, once the agreement is produced, that question is gone. I think it's also, in this case, it's not even a third-party rental, which this court has said might minimally contribute to reasonable suspicion. Here, Mr. Robbins himself rented the car. So I don't think the fact that he rented the car contributes.
But nobody has this agreement till to look at. The other officer hands it to Coke, and then the other officer leaves and starts his little routine with having the defendant put his hands on the vehicle and stand back and then make room. I mean, it was almost instantaneously after the agreement is delivered to Coke in the car, in the vehicle, and the search by the dog. It's almost instantaneously, in a matter of seconds.
Your Honor, the timeline is not correct. It's close to 2 minutes until the dog sniff occurs. There's never been any allegation.
2 minutes from when?
So he receives the rental agreement at around 11:30, and the dog sniff, and I don't want to say exactly how long it was, but I believe it wasn't until around 13:30.
Wait a minute. The officer, what's the other officer's name? Craig?
I don't recall his name off the top of my
Whatever
head.
his name was. He has the phone that has the agreement on it, correct?
Your Honor, Coke receives the phone with the agreement at approximately 11:28, which I believe is 2 minutes or so before the dog alerts. And this is a factual question that the district court found in Mr. Robbins' favor. There's never been any argument or suggestion that they were unable to read the rental agreement or that any question regarding the owner or the ability to drive the car existed after the rental agreement was received. And, your question was also like, haven't we found reasonable suspicion cases like this?
I want you to go on before I go there. It will be clear if I look at the sequence events that it is clear that there were 2 minutes that passed between the time that Coke had the phone with the rental agreement and when the dog sniff started. That's at least 2 minutes.
Your Honor, I don't want to, I don't know if it's like 90 seconds or 2 minutes or 2 minutes and 30 seconds. I noticed in the suppression hearing, people call it 3 minutes. I think it's less than 3 minutes.
Than a minute and a half.
But it's more than seconds. It's well more than a minute. I think it's around 2 minutes. And just, Your Honor asked about other cases. I think this case just falls really short of what counts as reasonable suspicion in other cases. In Simpson, you have numerous inconsistencies which only contribute in combination with bizarre travel plans, a criminal history of dealing drugs, and extreme nervousness. And there, this court said it was a close call. Here, there's nothing else. And I don't think it's that close of a call. I think there's no reasonable suspicion. And I would point out this court has never found reasonable suspicion based on a single factor, let alone a factor that's equivocally suspicious as the statements here, which again, I just don't think meaningfully indicate any connection with drug dealing. It doesn't eliminate any substantial portion of the innocent public. And so if you look at the inconsistent statements or in the record, there isn't reasonable suspicion, and therefore we'd ask you to reverse.
Okay, let me ask you this. Do we view this from a subjective perspective of Officer Koch or from an objective perspective of the reasonable officer under these circumstances with a roadside stop?
So reasonable suspicion is a legal question that this court reviews de novo, viewing the evidence objectively. To the extent that there is sometimes deference owed to an officer's interpretation of evidence as suspicious, the district court didn't accord Officer Koch any such deference in this case because he found that Koch's testimony was not credible. That credibility determination is a factual finding that this court must defer to on appeal.
I understand. I think the dubiousness stuff is from the magistrate is much more limited than you say it is. My question is different. Do I view this from a subjective perspective of Officer Koch or from an objective perspective of the reasonable officer in this setting at on the highway? Which one?
Your Honor, I believe it's a legal question this court reviews de novo, and I believe the question is whether there's particular and objective circumstances from which to conclude there's reasonable suspicion. So I believe it's an objective standard. And again, if there's no further questions, I'd ask this court to reverse the denial.
Thank you.
Sorry, I keep muting myself. Judge Murphy, did you have any other questions for Ms. Shan?
I have none.
Judge Rossman, did you?
No, thanks.
Okay, thank you. Ms. Williams, we'll hear from you.
Good morning, Your Honors. Nice to appear via Zoom. Lisa Williams, representing the United States of America. I would like to pick up kind of where we left off and nail down this timeline because I do think it is very important. So the district court, the video evidence demonstrates that 11:52 is when the phone with the rental agreement is handed to Trooper Koch, and it's Trooper Kraft is the other trooper involved. And then the district court finds that at 12:11, so 19 seconds later, Trooper Kraft is asking the defendant to exit the vehicle. Now that's part of the sniff process. So Trooper Kraft initiates the process to conduct the free air search immediately after handing the rental agreement. Part one is getting the occupants out of the vehicle, securing them, and then he gets his dog and he runs the dog around and does the search. The dog begins the search at, I'm sorry, I had it right here. Here we go. At 13:20. And then the district court finds that at 13:36 is when the dog alerts. And I think everyone agrees that once that dog alert happens, that's when we move out of reasonable suspicion territory into probable cause. And so what we have is a period of time from 11:52 to 13:36. So it's less than 2 minutes, but again, the process to initiate the search happens instantaneously as soon as he receives the rental agreement. And here's the thing.
I don't understand why that would cut in your favor. It seems to substantiate Ms. Shin's point.
I'm not sure I agree with that. Because when Trooper Koch is in the car and receives the rental agreement, he has to review the rental agreement. He has to finish writing the ticket and he has to print the ticket. The receiving the rental agreement does not end Trooper Koch's involvement in the ordinary business of the traffic stop. And so he's still doing the ordinary business of the stop while for the next minute and a half, Trooper Kraft takes the dog around the vehicle. And that's why it cuts in the government's favor. It's not so much with the reasonable suspicion argument, right? It's whether or not there's this Rodriguez moment.
Well,
And
aren't you on clear error for that?
Well, Your Honor, the government's position is that the finding of a Rodriguez moment isn't factual, it's legal. And so we would say we're not on clear error because it's not a factual decision. It's a legal conclusion, whether or not it ended. And even if we were on clear error, the court has the video evidence, and it's clear that when Trooper Koch receives the rental agreement, he's not done writing the ticket. In fact, after he receives the rental agreement, he continues to ask the driver of the vehicle what he does for a living, which under this court's precedent, questions about employment and what you do are proper purposes for the traffic stop. So
but
putting
the Rodriguez moment doesn't, I mean, that could have taken place at any moment when Trooper Koch, whatever his name is, when he stops the vehicle. I mean, it doesn't have to be at the end at 13:20.
Well, it has to be when the business of the traffic stop has concluded, when you divert away from the business related to the traffic
And that
stop.
could have started at any time. In other words, if he, let's say when he contacted the K-9 officer, if he, put down the warning pad to contact the K-9, that could be a Rodriguez moment, right? It doesn't need to be at the end. It could be at any time if, as you point out, Ms. Williams, if he diverted from the mission of the traffic stop.
Yes, I would absolutely agree with that, Judge Bacharach. But in this case, the government's position is that he didn't divert from the mission of the traffic. The things that Trooper Koch is doing are related all to the traffic stop, including the questions he's asking Mr. Williams in his car. Now, Trooper Kraft and the dog have nothing to do with the traffic stop, right?
Okay.
That's the diversion.
Okay.
But that activity is going on at the same time that Trooper Koch is on mission with the traffic stop. And
Counsel, this argument all goes to the government's position that we can affirm on alternative grounds, right?
That's correct, Your Honor.
Okay, so if we could turn to the principal ruling that the district court made here. My question is, again, it's similar in quality to what I was asking Ms. Shen, which is trying to really understand what the scope of our review is when it comes to the factors that support reasonable suspicion. And the government, as I read your brief, narrows our inquiry by your choice of factors. You rely on the defendant's inconsistent statements, which is what the district court found dispositive. In addition, you point us to Mr. Williams' nervousness and the dashboard photo. You don't talk about other factors that the district court considered and rejected. So my first question is, should we confine our review not just to the inconsistent statements, as Ms. Shen is arguing, but to these three factors that the government posits?
Your Honor, you don't have to confine your review to just those three factors. This court can affirm on any ground supported by the record, which is what the government.
But you selected those factors, so doesn't party presentation matter in our adjudication of a reasonable suspicion challenge, particularly because these cases are so fact-bound, right? So even if our ultimate review is always going to be de novo on the Fourth Amendment question, something has to direct the court's attention to what matters in a given case. And here the government has chosen, in its view, what matters. So why should we not confine our review in the way the government has advanced in this case?
I don't think party presentation has ever been read that narrowly, Your Honor. I think that certainly the principles behind party presentation is that the court won't step outside of the issues to find a new legal theory that the parties don't present. But certainly in a case like this where the court has the full record before it, party presentation wouldn't consider this court from considering a factor such as the car was rented and that the individuals weren't able to immediately produce a rental agreement.
What about the credibility determination, the adverse credibility determination? Does that impact every finding other than what the district court said in footnote 7 of its order, that other than the video? Because the court said the video doesn't depend on the trooper's credibility. So is a correct way of reading the district court's order that the only thing that doesn't depend on credibility is the video, and the credibility is discounted in this case? We defer to that finding and move on. Is that the right way to look at this?
I do think one of the toughest or most challenging parts of this appeal, Your Honor, is what about this credibility finding? And so what I think the court has to do is really pick apart what was said and what was found. What the district court said is the magistrate judge expressed concerns about credibility. I agree. Right? So the district court didn't make any new independent credibility findings. They just adopted what the magistrate judge said. So to really understand what the credibility issue is, I think the court has to look at the report and recommendation. And what the magistrate judge found were simply that many of Trooper Cox's stated bases were of dubious value as a foundation to form a reasonable suspicion, and in other instances simply did not exist from a review of the video evidence. So
did the government make any objections to the magistrate judge's determination of the trooper's credibility?
Your Honor, I'm sorry, I don't know the answer to that. I don't have the the government did file that they didn't title it a report, an objection, but it was a response to the defendant's objection to the R&R, and the district court treated it as the government's objections. And I am sorry, I don't know if we address that in there. Here's what I talking about reasonable suspicion, though. I think I really want to highlight that the defendant conceded during her argument that there are times in which inconsistent travel plans standing alone would be sufficient to form reasonable suspicion. That was a concession. Now, the defense argues this is not that case, right? But there is that concession there. I think that they have to concede that based on the prior precedents. And so really what this court has to do is review, okay, what about what's the nature and substance of these inconsistent travel plans? And the government submits, they're very inconsistent. The Orcaso-Rivas case from 2020, which the government cited in its brief, it's unpublished, but there it found reasonable suspicion based on part with inconsistent travel plans. And the inconsistency there was that one person said they were going to her uncle's ranch to help clean up, and the other said they were visiting her friends to help build a fence. Like, that is not very inconsistent, right? They're both kind of maybe going to the same place. They don't understand, but the court found that was an inconsistent travel plan. Here, what we have is—
wait a minute. In that case, I thought you said there were other factors for reasonable articulable suspicion, correct?
That court, yes, Your Honor, found.
Okay. All right. That's all I wanted.
But yes, but they noted.
Yes. I understand. My question is, what cases say that travel plans alone in certain circumstances can be enough for reasonable articulable suspicion, which is contrary to United States versus Santos?
Well, I think the Wood case would say that, Your Honor, because the quote from Wood is, as with unusual travel plans, inconsistencies in information provided to the officer during the traffic stop may give rise to reasonable suspicion of criminal activity. And that doesn't say inconsistencies in information combined with other factors. It is just point blank says inconsistencies may give rise to reasonable suspicion.
So that puts that feels like it puts the appellate court in quite an awkward position. You know, if we're analyzing whether an inconsistent statement can give rise to reasonable suspicion, our cases generally look at that in the context of that specific case. Are there other things that also weigh in favor of reasonable suspicion? It seems that what the government is positing would require us to decide how inconsistent something is. Is it super inconsistent? Is it medium inconsistent? And that seems to me not to be the tenor of our the scope of our review.
And I'm not arguing that, Your Honor, and I apologize if that wasn't clear. What I am arguing, though, is that is a sufficient ground to affirm the district court's decision, that the district court found that that gave rise to sufficient reasonable suspicion, and this court's review of that order should be affirmed because it is a permitted basis. There's no it's not clearly erroneous that they provided different.
Well, I thought, just to clarify, I thought what you were saying is that it's not just we affirm the district court found inconsistent statements support reasonable suspicion. Government's position is we can affirm that. I thought you were saying we also had to affirm because it was very inconsistent.
Oh, no,
Okay.
I think to the extent that the court would get into weighing the totality of the factual of the facts behind the inconsistency, I am saying this is more inconsistent than other cases. But I do think that this court owes a degree of deference then to the district court, that once you get past the legal issue of can inconsistent travel statements standing alone provide sufficient reasonable basis. If this panel says yes, they can, then at that point you should affirm the district court.
Well,
because then the deference to the.
Can I push back on that and follow up on Judge Murphy's point about Santos? In Santos, the panel did say that other courts have accepted similarly evasive or inconsistent accounts. We stress, however, that conversations of this sort is not sufficient in and of itself to warrant detaining or searching a motorist. And so, and Santos was adjudicating reasonable suspicion as a matter of law. And so on this very uncomfortable inquiry that we're confronted with, to make this legal adjudication as characterized in Santos, don't we have to compare what was on what appears on the video as these inconsistent statements to Officer Koch in comparison to the inconsistencies in Santos? And we, the three of us, will say, oh, well, these are worse. These are more inconsistent than what was presented in Santos, or not as bad. And if they're not as bad, aren't we bound by the panel opinion? Because that's an adjudication of law.
So Santos is easily distinguishable, Your Honor, from this case, because Santos is a single vehicle occupant, and the inconsistent statements were not two different people providing dramatically different inconsistent statements. And so it's one person over the course of a conversation having some internally inconsistent statements, which if you look at what was inconsistent about Mr. Santos's statements, the panel found, and sometimes they're not even really that inconsistent. So I don't think that Santos applies here when what the inconsistency is between two people who don't have the same story. Likewise, there's a line of implausible travel stories. Those cases don't really apply here either, because this isn't an implausible story. It's an inconsistency between two people who should both know where they're going. And I see that I'm out of time.
So you are saying that a panel sitting like this, if they're faced with an issue of statements of travel plans, they need to dissect them and decide whether there are inconsistent travel plans between more than one person's in the traveling car, or whether they're internally inconsistent statements by a single person talking that was in the car, and I think you had another third category. So we have to do that whenever we're faced with these things, and we apply different rules to the three different categories?
No, Your Honor, I don't think that this panel needs to get that fine into the weeds. To me, the distinction is how this court has said, nervousness by itself does not give rise to reasonable suspicion. It has to be extreme nervousness, right? There's that line. And the distinction I'm drawing is just like it has to be extreme nervousness, there is a bit of a difference between implausible travel plans and inconsistent travel plans between a driver and passenger. I think it's just categorically, it's a different type of evidence that enters into the calculus.
Understood.
Judge Murphy, did you have any other questions for Ms. Williams?
No, I don't.
Judge Rossman, do you?
No, thank you.
Okay, thank you, Ms. Williams. Kevin, does Ms. Shin have any time left?
No, she did not.
Okay, sorry about that, Ms. Shin. I think that was my fault again. So, but very well presented by both sides. This matter is submitted and will be adjourned until I think 8:30 Mountain Time tomorrow. And if I can ask my colleagues to stick around.